first of the 2024-2025 Rothenberg Healthcare Law and Policy Speaker Series. Whether you're joining us for the first time or have been a frequent attender, we're very glad to have you join us today. And for those of you who don't know me, I'm Diane Hoffman. I direct the Law and Healthcare program here at Maryland Carey Law. And today I'm thrilled to kick off this year's series by welcoming our distinguished guest and a pioneer in the field of health law and policy, Sara Rosenbaum, who's the Harold and Jane Hirsch Professor of Health Law and Policy at the George Washington University School of Public Health and Health Services. And I know you are all here to hear her creative and expert insights into the journey from legal segregation to the Affordable Care Act and how law can make a difference. But before I turn things over to her, I just wanted to share a bit about the speaker series. This series of virtual lectures is, I think, an effort to bring to the screen highly regarded and groundbreaking voices in healthcare law and policy, thanks to the generous funding from the Karen Rothenberg and Jeffrey Seltzer Law and Healthcare Program Endowment. Professor Rothenberg was a former dean of the law school and the founder and director of the Law and Healthcare Program. Past year's themes have included health inequities exacerbated by the COVID-19 crisis, genetics, and reproductive health care. This year, which is our 5th year of hosting this series, our theme for the year is discrimination in the healthcare setting and how the law can work to minimize healthcare disparities. And when thinking about who would be a good choice to open our series on discrimination, Professor Sara Rosenbaum immediately came to mind. Professor Rosenbaum is Professor Emerita of Health Law and Policy and founding chair of the Department of Health Policy at the Milken Institute of Public Health at GW University. And she holds an Emerita title at the GW School of Law. She has devoted her career of nearly 50 years to issues of health justice and healthcare for medically underserved populations, serving presidential administrations and Congress, while teaching, writing, and speaking on important issues of health law and policy. Professor Rosenbaum is perhaps best known for her work on national health reform, Medicaid, health insurance and managed care, healthcare access for medically underserved communities and populations, and civil rights in healthcare. She has also received numerous awards for her nationally recognized work, including the prestigious J. Healy Award, which Professor Rosenbaum won in 2024 for her dedication to teaching health law and her inspirational work in the field. Today, Professor Rosenbaum will speak about the history of discrimination in healthcare and efforts to fight against discrimination using health law. So please join me in welcoming her to the series. Welcome, Professor Rosenbaum.
Thank you so much, Professor Hoffman and Dean Rothenberg. And I should just note that the health law program at the University of Maryland is one of the great North Stars. It is just a phenomenal program. And those of you who are learning in the program or affiliated with the program are really so fortunate to have the privilege of being affiliated with the program. So when Dean Rothenberg and Professor Hoffman reached out along with Professor Hall, it was like a no-brainer. I mean, would I like to do this? You'd bet I'd like to do this. So here I am, and my plan this afternoon is to speak for about a half hour with lots of time, hopefully, for questions and discussion. The topic, of course, could not be more important. Civil rights and healthcare is once again front and center on the Supreme Court's agenda this term, and I'm sure we'll talk a little bit about that. And what I hope to do is put the whole issue into some historical perspective. I want to acknowledge also, because I know he's listening in today, my longtime collaborator, Professor David Frankfurt, who has toiled away on health law with me and the textbook that we produced for decades now. And much of that textbook is devoted to healthcare access and health justice. So it's a great honor to be here. So let's go ahead. I have some slides just to guide the discussion. I'm a terrible slide maker, but I thought just some points to follow along with. So if you could put up the first slide.
The health law Zoom is pretty good if you're doing a health law program.
Oh,
I'm gonna do
Can you put up the first slide? This is the title slide.
Is this the one?
Can we move the slide forward?
Yes, I think Ian was going to advance the slides. If that's not possible, I have there. Okay, great. So I think the starting point for this afternoon's discussion is discrimination in the American healthcare system, sort of just a perspective. Unfortunately, the American healthcare system really is no stranger to discrimination. I mean, this is something that is in some ways really embedded in the healthcare system. And I was thinking about this before we began today. Often when we talk about discrimination, of course, legal discrimination can be in the form of intentional discrimination or de facto discrimination. And I have reached the conclusion that in healthcare, there is no such thing as de facto discrimination. That is, that it is possible to employ what appear to be facially neutral practices with full knowledge of how those practices will land on disadvantaged populations. But we're going to talk about the full range of discriminatory practices today. And of course, the starting point is race discrimination in American healthcare. It was by no means the only form of discrimination of its time, but it left a particularly searing mark on the healthcare system because, of course, it was by law. We endured legal segregation and exclusion for generation after generation. And the important thing to understand is not just that it was presence, but what shapes and forms that presence took. Because what you can see in the through line of discrimination in healthcare is the ability to adopt old practices that were literally sanctioned by law into a fully privatized system and actually preserve their effects, but as what are referred to as neutral practices. So, in the days of purely legal discrimination, hospitals by licensor status were required to maintain separation if they were allowed to admit patients of color at all. Of course, segregated waiting rooms, hospital floors, nursing home wings were the norm. I have to say that when I began my practice as a full-time health lawyer with the National Health Law Program in 1977, the first thing I was confronted with, so this is almost 50 years ago, was a segregated waiting room case in Florida. One of my colleagues was handling a segregated waiting room case in 1977 in the state of Florida. And one of the most interesting forms of discrimination, which is one of those types of strategies that takes on many permutations in the modern world, is the personal physician rule, that you had to have a personal physician in order to get health care. And of course, personal physicians or physicians in communities would not see Black patients and or patients of color. And so that maintained a segregated system even without a law requiring them to do so. Of course, I'm sure everybody here is familiar with Tuskegee, and I raise it here because it went on so long. I mean, it was really not exposed until 1970 for all practical purposes. But it was an archetypal example of withholding essential medical care that was needed to avert long-term disability and death. And it was shocking in the form it took. But what we see as a through line is efforts to withhold essential medical care. So that's why it's up here today. Medical society membership is a condition of admitting privileges. This was another way, of course, of keeping out Black physicians who were likely to see Black patients. They couldn't belong to their local medical societies, and so, of course, they couldn't get admitting privileges. Redlining segregated communities out of hospital service areas, literally barring them from access to providers often very close to them, and of course the medical staff refusal, which became evident after 1965, to participate in the Medicaid program, which is a program that disproportionately serves patients of color. I should note, and I think it's always important to understand what drove this. I mean, it was driven by the fact that segregation was the norm across American society in many states. But particularly important is to understand that a fundamental issue in this kind of overt discrimination was a fear of commingling of the races in their blood. And so we are talking about such a visceral driver of discrimination, but one that has eerie through lines in American society right up to the present. Next slide, please. Again, it's of course, it's not just race where we've seen this kind of behavior. Discrimination based on disability is embedded in the American healthcare system. And we've seen it, again, the patterns and the drivers and the case examples stay with us. The victims of discrimination are different groups of people today. Exclusion and segregation during the AIDS epidemic was the norm in so many places. Refusal to treat, separation laws to isolate AIDS patients and essentially exclude them from society. And we begin to see, of course, the kinds of behaviors that, again, are called neutral, and they were decided by the courts as neutral at the time. They were treated as neutral. They are, if you know anything about American health insurance, they are by no means neutral. An insurer would simply exclude AIDS and AIDS-related conditions as they were known, which was basically any condition experienced by somebody with HIV/AIDS, from health insurance coverage design. So even if you could have a policy, if your treatment need was for AIDS or what was called an AIDS-related condition, which was, of course, as broad as insurance was, you were denied care, or care was capped at an absurdly low level. Now, one can say that excluding a condition is a facially neutral practice, or facially neutral policy, and we know in practice that is no such thing. People who design insurance are extremely aware of the choices they make in insurance design, and we'll see this come back in modern times, and it was explicitly addressed by the Affordable Care Act. When it came to mental illness, we saw the same kind of pattern: legal segregation of people with serious mental illness into inappropriate institutional settings. And again, we saw coverage exclusions. And the favorite form of coverage exclusion, which just permeated insurance practices and is very much with us today, is the recovery standard or the restore normal functioning standard. And there is case after case where we find that you don't have to redline the patient anymore. You just simply say, we're redlining a condition. We are not treating conditions from which recovery is not possible, or from which restoring quote unquote normal functioning is not possible. And it's not just the overt actions on the face of a policy or a summary plan description. It shows up, of course, in treatment guidelines. So this is a huge issue, a way to build discrimination into insurance norms and treatment norms. and call them facially neutral because it's a coverage design matter. Next slide, please. And of course, on the basis of sex, we are all painfully aware of discrimination on the basis of sex. The early form that attracted so much attention was, of course, the problem of pregnancy-related insurance exclusions, health insurance, disability insurance. I think some of you on this call may be old enough the way I am to remember this. I was not insured. I think I just had acquired insurance for the birth of my daughter. The Pregnancy Discrimination Act had just passed, but my husband and I were made to prepay our obstetrical care, prepay the hospital delivery, because I think we were still on the wrong side of our insurance policy. It was routinely excluded from coverage, again, a coverage exclusion. And of course, today we're living through discrimination on the basis of sex, discrimination very overt on the basis of gender identity and sexual orientation. Next slide, please. We will come back to that. So we see a remarkable evolution of civil rights in a healthcare context. And this has been a subject of focus by Congress, by successive administrations, by innumerable entities, both public and private, that have studied this. The most recent is a study that I was privileged to be part of that came out in the spring called Ending Unequal Treatment, which was a 20th anniversary retrospective published by the National Academy of Medicine that considers discrimination and the progress that has or has not been made since the initial landmark study, Ending Unequal Treatment, was first published. That study, of course, most famously documented unconscious bias on the part of physicians in the diagnosing and treating of Black patients. Section 504 of the 1973 Rehabilitation Act, the 1964 Civil Rights Act, where we see, of course, the public accommodations provisions that really did not address healthcare. People did not consider healthcare one of the public accommodations bound by the 64 Act. Title VI was really the landmark, and healthcare was one of the great drivers. If you read some of the history around Title VI, particularly David Barton Smith's writing on healthcare and civil rights law, you understand that Title VI was remarkably tied to discrimination by federally funded healthcare entities, particularly hospitals. And if you know your history about the interplay between Title VI and Medicare, you know that in order to get Medicare enacted the year after Title VI was enacted, the Johnson administration had to promise informally, it was never committed to statute, but promise informally that Civil Rights Act would not be applied to physicians. Now that has changed as a result of the new 1557 rule, which we'll talk about. And of course, Title VII in employment dealt with discrimination and dealt with discrimination on the basis of race, color, national origin, and sex. And this becomes highly relevant to the evolution of civil rights law. The 1973 Rehabilitation Act, of course, was driven again by the national outcry finally against the segregation, exclusion, and discrimination acts committed against people with serious disabilities and the problem of unnecessary institutional care. The Pregnancy Discrimination Act, which sort of dealt with it was designed to deal with a very specific problem in which the Supreme Court refused to recognize exclusion and denial of care to pregnant people as discrimination on the basis of sex. The Emergency Treatment and Labor Act, which of course has been so front and center over the past couple of years now, ever since the Dobbs case was decided. EMTALA is one of the most fundamental civil rights laws we have by ensuring access to emergency care regardless of any personal characteristic. The Americans with Disabilities Act, which most interestingly for our purposes, extended the concept of a public accommodation front and center to healthcare. It really, healthcare had been approached again from the federal financial participation perspective. But here now, finally, in the Americans with Disabilities Act, we see this tremendous step forward in the connection of healthcare to the concept of a public accommodation. The Age Discrimination Act, of course, played a crucial role in healthcare, and ultimately 1557 of the Affordable Care Act, which we will talk about. Next slide, please. Again, there is disparate treatment and disparate impact. Both are recognized forms of discrimination in healthcare and civil rights. Perhaps it's my age and my experience. I look with a jaundiced eye on the whole concept of disparate impact. I think by now we know extremely well what the effect is going to be if we draw seemingly facially neutral policies that ostensibly apply to everybody, insurers, healthcare systems. There's no entity that doesn't understand in healthcare what kind of effect a facially neutral practice is going to have. And so one of the things that, I think a lot about is whether we really ought to be doing some deeper thinking and writing about the whole issue of, is there room anymore in American civil rights law and healthcare for a claim that something is facially neutral? Of course, civil rights and enforcement became this huge issue in the wake of Title VI. And the first cases, again, this was, the classic example. The early cases, the cases that I worked on back starting in the mid-70s were known collectively as the hospital siting cases, the hospital privilege and insurance participation cases. Cook v. Oshner, which was hospitals just announcing that they didn't accept Medicaid, their staff didn't accept Medicaid. Bryan v. Koch, one of the great hospital siting cases where hospitals either were closed or moved themselves out of poor and minority communities to much more affluent locations, again, treated as facially neutral, which of course gave rise to all kinds of defenses that you don't have in an intentional discrimination case, such as what is known as the business necessity defense. ADA 504 cases. The most prominent cases, I think, were, of course, Olmstead, which I assume many people may be familiar with, a case in which we see the drive to not just deinstitutionalize people, but give them appropriate care in communities that both directly and indirectly led to the complete redesign of the Medicaid program. Beginning with the Olmstead decision itself, the past 25 years have witnessed really profound changes in Medicaid to begin to mitigate the effects of a law that was designed initially as an institutional care law. That's what it covered. To the extent it covered institutions, that was the necessary care it covered for people with disabilities. And of course, that is no longer the case today. I mentioned healthcare as a public accommodation. The landmark case in this field is Bragdon versus Abbott, in which a dentist in private practice refused care to a person seeking care who was HIV positive. on no basis whatsoever. And for the first time, we see healthcare classified by the United States Supreme Court as a public accommodation and subject to public accommodation law where the ADA is concerned. We saw, of course, a great setback around the turn of the 21st century with a case called Alexander versus Sandoval, which eliminated, this is what's made me think about this issue over all these years, eliminated the use of Title VI in disparate impact cases. My personal response is fine, let's not call them disparate impact cases anymore. Let's not call these things facially neutral practices. They are not facially neutral. And there is a question as to whether, in fact, Section 1557 in its design of both prohibited actions and legal protections also restores remedies that were taken away from the race discrimination cases. Next slide, please. So the thing that I want to turn to, the point I want to turn to now is what we're dealing with here. We have these bodies of law. And we have made great strides where the law is concerned, and even where the law relates to the healthcare system specifically, we've made great strides. But the fact of the matter is that disparate treatment remains alive and well. Whether you call it disparate treatment, disparate impact, I think this is so much sort of wordplay at this point. And we see certain kinds of activities labeled as such. The most prominent example, of course, that we're all living through at the moment is the deliberate targeting of people who are transgender for exclusion from care and exclusion from coverage, where there is no bones about the fact that keeping them out of healthcare is the whole point. So much so that the Supreme Court is now having to decide whether acts that are obviously overt discrimination on the basis of sex, we know this from Bostock at this point, and Title VII, whether those kinds of behaviors are going to be tolerated in the healthcare system. What we call disparate impact tends to be the norm in healthcare and civil rights, in the sense that we call certain kinds of choices, policy choices and practices, facially neutral when they're not really. And here what we see is this constant effort in a highly privatized, unbelievably complicated healthcare system to cloak itself in the mantle of design. Oh, this is not discriminatory. We just design things this way. Insurance is designed to deal with what we call healthcare norms or health norms. And somehow it is not within our actuarial norms to include certain kinds of treatments and certain kinds of conditions and certain kinds of diagnoses and certain kinds of human beings. They fall outside our norms, and we call this a facially neutral practice. And this kind of really angels dancing on the head of a pin is, I think, one of the great frontiers right now in healthcare discrimination. And so I think of it as noted as sort of an original sin of the modern era. Yeah, let's design things. Let's design things to work for some group of people who we are happy to have the healthcare system work for. And of course, the core design issue, which we are no closer to resolving than we were when I began my practice over 50 years ago, and who knows, is the creation of separate and distinct forms of insurance. I mean, once you do that, once you design the insurance system to have insurance for people who are in a position to work, who are who fall within whatever health norms insurance actuaries are willing to recognize, and companies are willing to invest in, with separate payment structures. At that point, you've consigned the American populace to a system where there is one insurance system for healthy, disproportionately white, disproportionately affluent people, and a health insurance system for old people, although we tend to be a mixed group, so it's a little more complicated. We get into sort of internals of practice in Medicare, but then a healthcare system that is driven by a public insurance program that is absolutely vital. We can't live without it, but that is so distinctive by the health of its beneficiaries and the color of their skin. And that is, of course, the Medicaid program, and subject to differential payment standards, all in the name of offering more in terms of coverage, but unwilling to pay properly for that coverage. And it's a structurally so embedded right now in the American healthcare system that we can kind of nibble around the edges of it as a problem, without resolving anything. We're always looking to mitigate the effects of this, but we can't really erase it. Then there is, of course, another whole category of built-in design issues, which is the underfinancing of essential access programs. Examples would be the Indian Health Service, the Ryan White Care Act, public health agencies, community health centers. These are all programs that are designed to anchor healthcare or health improvement services in underserved communities that bear a disproportionate burden of poor health, and they are chronically underfunded. In our new unequal treatment report, we deal extensively with the Indian Health Service. Congress had a chance in 2010 to address the IHS underfunding problem and did not. Other programs other than community health centers, which were given some additional funding, by no means enough, but additional funding, these other programs were left really without the money they need to operate fully and fairly. And of course, these are public programs. They have no access to venture capital. They have no access to private equity. Nobody is going to invest in making sure that IHS run facilities reach more people. It's not where private money goes. And of course, then with each form of insurance, we have this problem of coverage design that I've mentioned. And it's built in. It's just an accepted fact that insurance, except for Medicaid, which is really designed as a public health program, and not based on actuarial norms. All these other programs, including Medicare, are driven by actuaries and what some person, I always wanted to meet who the person was who decided what the norm was, what the norm in health was, what the norm in disability recovery is, what the norm is, and everybody else is essentially pushed out. Another, of course, way to design a system that looks facially neutral but is by no means facially neutral is the design of a provider network. Much attention was paid to this issue in the Affordable Care Act. Certainly steps were taken to try and mitigate discriminatory network designs. Obviously, there's an inherent problem of poor communities simply lacking the resources. They don't have networks, but then where is telehealth? Where is transportation? Where are other services? But even more pernicious was the redlining of certain providers. The Affordable Care Act attempts to deal with something called the essential community providers. And if you look at the regulations on essential community providers and the design of Affordable Care Act marketplace plans, there are these tortured formulas for when do you have enough essential community providers? You know, can you exclude a third of them? Can you exclude half of them? I mean, as opposed to if there's an essential community provider and it's qualified to deliver healthcare in the community, you have to include the provider. So some mitigation, but again, this sort of, you know, allowing quote unquote neutral design. So we don't want any more than 12 ECPs in our network. Why? The discriminatory effects of treatment guidelines, something that we've had to deal with more and more. And the most celebrated in the worst sense of the word example may be what happened to Black patients who needed kidney transplants and were pushed off lists or pushed way down on lists because of absurd assumptions about the severity of illness in their cases. Of course, the absence of language accessible services. Next slide, please. Section 1557 of the Affordable Care Act is quite a revolutionary civil rights law. It was an effort to overcome some of the structural issues that we've talked about, along with the ACA itself. And the most important of those issues were, first of all, the extension of the ACA to the entire healthcare system. Public accommodation versus not public accommodation no longer really matters, because the whole idea of a federally assisted entity is an entity any part of which gets federal financing. So United Healthcare, I don't mean to pick on them, but just as an example, as a company, is covered by Section 1557 because some of its product lines are obviously federally funded, Medicare Advantage, Medicaid, et cetera. And far-reaching regulatory interpretations that reach design as well as practices. So we see the emergence of coverage exclusions, coverage limitations, categorical sort of limits on benefits as potentially a violation of federal law. And most prominently at this point, given what's going on at the Supreme Court now in a related case, the Scrimeti case, but you can see the 1557 cases are going to land at the Supreme Court probably in not the not too distant future, is the inclusion of discrimination on the basis of sex as a prohibited activity by federally assisted healthcare entities. We are dealing here, and maybe we'll get into it in the discussion period, with a deeper issue, which is now lurking in the EMTALA case, the case that is now pending back with the Ninth Circuit in Idaho, and that is whether, in fact, federal efforts by Congress to overcome discrimination or ensure a basic standard of care for all Americans amounts to an unconstitutional coercion on the states. This door was opened in the landmark case NFIB versus Sebelius, which of course is the case that upheld the legality of the Affordable Care Act and its constitutionality, while at the same time overturning the Medicaid expansion as an unconstitutional coercion on the states. We now see that theme being developed by opponents of civil rights and healthcare and carried over into new areas of federal spending that have nothing to do with grants and aid to states. And this is an extraordinary development that I think has not gotten the attention it deserves. I think, is there one more slide? No, I think we're done with slides. So we now, I think, have time for discussion and comments, questions.
Yes, absolutely. So thank you so much for that incredible overview of the history of discrimination in healthcare and what's, the challenges that we still have before us. I'm sorry, what happened? I thought I was on. So if you do have a question, please just go ahead and raise your hand using the raise hand function. I guess until I see someone that's hand raised, I guess I can start with a question, which is kind of, so you've been focusing on what's happened up to now. Are you optimistic or pessimistic about the next 5 years in terms of discrimination in the healthcare system?
Um, I think it's mixed. I think it's mixed. I think we are in, of course, an unbelievably fraught moment with discrimination on the basis of sex. I mean, there is simply no if and or but about it. Both where the individual who needs health care is a female, and a pregnant female, but also, of course, this whole issue of transgender people and their need for healthcare, where again, I mean, the transgender battle is a battle that has all the whiffs of the worst of the race discrimination, the worst of the disability discrimination, absolutely intentional identification of a group of people who are the most vulnerable people, and become scapegoats for extraordinary scapegoats who are literally being kept out of healthcare. And this is, I think, such a shocking development. And I've done a little bit of writing on the fact that, you can't view the transgender cases as transgender cases. You have to view them as the current iteration of this kind of shocking exclusion of a group of identifiable people from healthcare. And that is very fraught. I think certainly on the community integration fronts, and on color and national origin, you certainly see healthcare systems attempting, in an extraordinary degree, considering their healthcare systems, to adapt their programs and services to populations that otherwise might experience exclusion. The redesign of Medicaid, as bumpy as that redesign has been, as despite the shortcomings in the redesign, I feel privileged to have lived through the past 25 years in the sense of the reinvention of Medicaid to serve people in a more equitable fashion. And I think this is something that states are actually quite committed to, even when they don't do the world's best job at it. And so the glass is, half full in certain ways. We invest in certain programs and services that we didn't before. But at the same time, I am so caught short by the EMTALA battle and the transgender battle, because we are seeing the worst of the worst. We are seeing what you would think went away with Tuskegee, the denial of essential medical care.
Absolutely. Oh, thank you. I see we have a question from Rob Kim. Rob, go ahead.
Hi, thanks. I had a question about healthcare data, because I know in a lot of contexts, there's a lot of fragmentation between data stores of healthcare data. So I was wondering if you found that this plays a role in sort of determining whether disparate impact is occurring.
So great question. And actually, in the report, the NAM report that came out this summer, we spend a fair amount of time on health data. Probably our single strongest recommendation was the complete overhaul of the Medicare provider claims system. I mean, if you look at health data, the core is the HCFA 1500 for physicians. It still is today. It's now the CMS 1500, and the hospital billing form, and everything driven by health in the healthcare system is a, is that me or not sure where it is? Everything is driven by what the CMS claims forms collect. Without building the routine collection of race data, for example, under the new OMB standards into these claims forms, there are no special studies we can do. There's no, NIH funded study 1 million showing discrimination. We need to have routine data collection, routine data analysis to understand where discriminatory patterns are. And I certainly agree that were we to collect such data, that in some ways does bring you back to discriminatory effects, because people would be, for the first time, confronted by the impact of innumerable policy and practice choices. Those policy and practice choices sort of, get by under the radar because we don't have the receipts from those policies and practices. And for all kinds of reasons, of course, the fight over adding race, ethnicity, language data to the claims forms has been particularly bitter. And we spend a lot of time in the report about the fact that most of the data that are needed are routinely collected by the healthcare system from patient intake information anyway at this point. So it's not a great leap.
We have a question on the chat from Shirley, who's asking whether medical malpractice has done anything to make healthcare entities more accountable in terms of discriminatory practices.
Certainly there's medical malpractice claims have the potential to result in fairer treatment. But I am unaware myself of whether there are cases in which the claim was negligence in the form of say a racial profiling of patients. Now, the kidney transplant cases are very interesting cases that way, because it was all about the selection of patients for a particular treatment. The claims in those cases, I think, are strictly federal civil rights complaints. But you certainly could make the argument of reckless disregard and willful negligence by providers and healthcare systems that used corrupt data to basically prioritize their wait lists.
Thank you. Charlie.
Hi, Sarah. Thanks so much for your talk. And as a fellow NHELP alum, I also worked on the data issue, so I'm happy to see that that's being brought up as well. I really want to thank you for so strongly condemning the healthcare discrimination against trans people. I completely agree. It is such the central civil rights healthcare issue in our time. I also feel very cautious as someone who's worked in that space, knowing that the tactics of the interests that are against providing trans healthcare have changed. And I think that from what I've observed, courts are more willing to be disingenuous when they are looking at what the law says and what what should be included, right, in the discrimination. I think that it feels like we have to fight so much harder, and I don't know how true that perspective is. So I wonder if you can share some of your perspective about the tactics and the legal tactics. Another thing I thought of is there state cases that are essentially like fraud, like tort claims against providers that are providing trans care, essentially saying that this is medical malpractice, right? So it's so pernicious, right? I think you're, again, like the strong words are so necessary. But what do you think about tactics for preserving access to care and fighting that discrimination? And how has that changed?
Well, I mean, I think 1557 claims are the strongest claim there are. And of course, in certain fields, in employment law, the Title VII cases have been successful in overturning arbitrary exclusions and rejecting this nonsensical argument on the part of insurers that it's an across the board exclusion. You know, this is not discriminatory. This is just, here are certain conditions where we don't pay for certain treatments. And the courts have had no problem seeing through that and saying, don't be ridiculous. You are paying for these conditions and these treatments if it's a cisgender person, without question, minor or adult. You just are refusing to pay for this treatment if the gender of the person is transgender. And of course, the other thing that has been so heartbreaking in these cases, and it's what, you know, made me think of the early race discrimination situations, is when you read the decisions, several of the decisions deal with the way in which the discrimination manifested itself. For example, in Scrimetti, I mean, the state's justification, Tennessee's justification for its law is they want to make people appreciate their sex. Now, that has nothing to do with whether healthcare is necessary. I mean, it's anti that. And in the particularly extraordinary case decided by a judge in Florida, which was then, of course, immediately contested on appeal. The judge put into his opinion the legislative exchange that happened during the floor debates over Florida's transgender law, not to mention the positions taken by the state surgeon general. And I mean, you might as well say we don't treat Black people. I mean, it's that kind of just overt behavior. And yet the court, you know, is having to confront something that is so self-evidently discriminatory. You sort of, it makes you want to cry.
Christina? Christina Meneses, do you have a question? You have your hand up. Well, while we're waiting for her, I think Karen has a question. Dean Rothenberg.
Yeah, I want to ask a very basic question.
Sure.
And a lot of people ask me this, and never a good answer. So a doctor can't say to a possible patient, I'm not going to see you because you're Black, or I'm not going to see you because you're old, age and race discrimination. But they can say, I'm not going to see you because you're on Medicare. Or I'm not going to see you because I don't take Medicaid. So what's that all about? I mean, that seems to be, you know, Medicare is associated with age, and Medicare, as you said, is proportionally associated with minorities. So what's the answer to that?
Well, I mean, Dean Rothenberg, you're exactly correct, which is, and that's why, to me, the separation of the population into different health insurance plans is an almost insurmountable problem when subject to discrimination, because we've now at least say, as a result of 1557, that there is the physicians no longer have the right to say, I take Medicare, but I'm not federally assisted entity. That much we've now resolved. But it is absolutely within the right of doctors. And we see this, of course, I'm glad you raised it, because where we see it also is in provider networks, where you'll have a network that is ostensibly available to people, let's say, enrolled in a United plan. And it turns out that network is not available to people enrolled in a United plan. It's only available to people in a United employer plan. But if you age into Medicare, or if you become a dual enrollee, what you discover is that your doctor doesn't participate in those lines of business. And so there's a phenomenal amount of discrimination potential within provider networks, even when you think you're in a plan that's going to give you access to, a network.
So the only way around that is not to have an Affordable Care Act system, but to have a government system. But that's not going to happen. This is about as good as we're going to get, I think.
And so I think we're in I think we are in this forever effort at mitigation. I mean, and we've taken notable steps in notable ways. But when you're trying to mitigate a disastrous situation, you see especially when you've worked in a field for a long time, you see the limits of what you can do, which is not to say you ever stop trying to mitigate the effects.
Thanks.
You. I see Christina now.
Yes, thank you. Apologies for that delay. This has been fascinating, and I'm so excited to come back to this type of work. In terms of mass incarceration, we have populations who are Black and Brown and who are essentially in the legal custody of the state or the federal government. And access to healthcare is so limited, and they've been removed from the insurance companies. They've been removed from any type of safety network that we've created for other vulnerable populations, but yet they are left singularly either in the hands of private prisons, who have to foot the bill for their care, and in turn they don't pay for anything, or they get removed and are able to be hospitalized on an emergency basis and qualified for Medicaid at a later point. Have you seen any movement or any type of progress in trying to change that system, and how people who are incarcerated, mostly who are Black and Brown, but also really affects transgender individuals of color who are now either housed in inappropriate cell blocks, or if there's anything out there that has been done for this particular extremely vulnerable populations, especially taking a look at when COVID hit. I honestly thought that people were going to have compassion and humanity and release those who don't need to be in prison long term, but they doubled down and kept everybody in. So have you seen any movement around that?
Well, I must say it's sort of like, Dante's circles of hell, right? You see discrimination, and you see more discrimination and more, and the population you're talking about now is like its own unique sub species of people who are in the victims of discrimination coming at them from so many directions. Their race, their status, their residential status, their gender identity. I mean, everything all working against them. I don't specialize in prison health, so I don't know. I have worked on the issue of the incarceration exclusion from Medicaid. We tried to deal with this in the Affordable Care Act, and some progress was made, in marketplace plans. And now the Centers for Medicare and Medicaid Services, some of you may be in states where your state is participating in one of the special new 1115 demonstrations to try and at least begin a little bit of Medicaid funded care to ready people to go back into the community. But I mean, it's a very grim part of the world when it comes to healthcare.
How about, would you take a couple more questions?
Couple more.
Okay. James?
Hey, good afternoon, everyone. I just had a question about the use of artificial intelligence when you talk about the non-facial decisions that insurers make. How can we protect patients against the use of AI by insurers to make decisions based on actuarial formulas that have non-neutral factors? And if possible, can those formulas be all-encompassing if that's in the realm of possibility?
So the whole question of the intersection of civil rights law and artificial intelligence received, of course, a fair amount of attention in the 1557 rule. We paid attention to it in the NAM study. And what you see is, I think, sort of a wholly unsatisfying, I mean, not wholly unsatisfying, but sort of unsatisfying state of play, which is an admonition by OCR, HHS OCR, and our drawing attention to it, saying you ought to be checking, the effects of the guidelines, the AI-driven guidelines you're using to see if you're getting disparate results or results that are counter to the well-being of certain isolated populations, and then you ought to adjust what you're doing. That suggests that these systems are the focus of extensive data collection, and that people are doing this kind of work as opposed to sort of self-analysis, which is very important, but it's a different issue from prohibiting the healthcare system from using AI-generated guidelines only if they have been tested and have been shown to be not discriminatory in their effects. And I mean, that's just not, as far as I can tell, is not going to happen. It's like AI generally, there is no attempt to slow down the adoption and internalization of AI while we consider its effects on society.
Thank you. And actually, I think that is the last question. So I want to thank you for a wonderful inaugural talk to get us started this year. Also, thanks to Dean Rothenberg for generously making these talks happen, and also to Jihan Gergis, our health law program specialist, who expertly coordinates all of the communications and technology for the event. So we also wanted to share some of our upcoming events as we kick off our fall lineup, which is commemorating the 40th anniversary of the Law and Healthcare program here at Maryland. So on November 7th, we'll welcome Erin Pusey Brown of Brown University School of Public Health. She's going to be talking about the financialization of healthcare and what can be done. A lot of the private equity issues we're seeing, and we'll follow that event with our 40th anniversary celebration. And then we're also very excited for our next Rothenberg Healthcare Law and Policy Speaker event, which will be co-hosted by the Gibson Bank Center for Race and the Law. On November 14th, we'll welcome Kiera Bridges from UC Berkeley School of Law to discuss expecting inequity, race, class, and reproductive justice. So you can find details about all of these and more in the chat, and we hope that we'll see you at many of them. So again, thank you all so much for coming, and thank you again to Professor Rosenbaum.
Thanks.
Take care, everyone.
Bye.